All right, cool. Let's get started. I'm just gonna do the intros and then hand it over to you, Matt.
All good, man.
All right, cool. Hey yo, hey yo, hey yo. What's up, everybody? It's a Monday and it's another day at boot camp. I'm really excited to see everybody here today, and we are gonna have a smashing session. Today we have some superstar guests in the building. Matt Green, Leon Hurt, Adila Holive, Palessa, Adela, Toulon Foster, Kinil, Devon. Yo, the list is endless. Before we start, I just want to send a shout out to everybody in the room. Just drop a flag or, just say where in the world you're coming from. I probably speak your language, so I'm going to big you up in your language. You know what I mean? Like, this is one community. I know we have Shanika Bowen, and she's all the way in Barbados. Yo, Shanika, big up yourself. Yo, guys, throw down your flags, yeah? Quick thing. No delay thing in this, yeah? Nah, the crowd today ain't crowding. Ah, I see Barbados.
Barbados, good.
Yo, the Kenyan people in this crowd, I'm gonna have some issues with y'all when I come down to the 254, yeah? Because Kenyans are always quick on their feet, but you guys kind of snoozing. Anyway, yeah, yay, the Kenyans now, yeah, big up yourselves. Yeah, that's how it goes, man. That's how it goes. Yo, Nigeria. I know we also have Nigeria in the house. Wagwan? Nah, man. Yo, listen, Matt, I'm gonna hand over to you. Do your thing, man. Big up yourself. Yo, +234, that's Nigeria. Yeah, big up yourselves. Yo, but I'm gonna hand over to Matt to introduce himself. So Matt is gonna be the main instructor for the session, and then we're gonna have the guest lab where we're gonna have Leon, Adila, Kinil, Adela, Palesa, and Devon as well. So, guys, Matt, the floor is yours. Let's get the party started.
Cool. Thanks, Brian. And hello, everyone. Brian, you want me talking for about sort of 40 minutes, an hour, something like that?
Yeah, thereabouts.
You-
Exhaust your presentation. Don't feel rushed.
Okay, all right. Well, yeah,
Yeah.
thanks for having me. I prepared a presentation, so bear with me whilst I share my screen. But essentially, this is what hopefully it's loading. Let's have a look. Can you guys see it? Cool.
Yeah.
Hopefully, yeah, there we go. Hopefully the GIFs work. So basically, this is the story of how digital assets, crypto assets, became property all the way from case law through to where we are now at the regulatory position. And there is a story to be told. The story relies upon certain case law that I and others have worked on. And what I'd like to be able to do is tell you that story today. So that's me. That's a good photo of me. I am a director at law firm Lawrence Stevens in London. I'm the head of blockchain digital assets there. And I'm also the chair of the blockchain digital assets working group at Tech UK, which represents tech businesses, I suppose, in Parliament government as a lobbying body. So, things that we'll cover today. What are crypto assets, cryptocurrencies, digital assets broadly? What AA and persons unknown is as a case, what it means, and the story behind it. Then we're going to look at how we apply to the court where there's been a hack or a scam and how we help clients get their assets back. And using that story in that context, how crypto, Bitcoin, everything else that falls under the umbrella became property and why we care about that. I'm going to run through, and Brian's going to take a contribution note here because he helped me with some of this, some of the key case law, and then legislative considerations afterwards. And then we can have a bit of a Q&A if Brian will let me. So we'll see how we get on with time. First of all, I'm sure you've already heard this. We're going to run through it super quick on the basis that I know that you had Scott Pounder and Brian Moore the other day, who probably told you exactly what cryptocurrency is and how it works. Broadly, though, it's digital money secured under cryptographic transactions on a blockchain. There is an unbelievable video that's been circulating, I think, for about 10 years on YouTube. I've got a link to it here. I can share it with Brian. He can put it in the chat. But it is a really great way to understand how hashing works and why we do what we do. Another way to think of them potentially is a store of value determined in the open market. You've seen the price of Bitcoin go up and down, predominantly shoot up, come down a little bit, maybe about 15 to 20,000 pounds since the start of the year. One thing important to note is that blockchain is typically decentralized, meaning that there's no central authority which operates it. That's in theory. So Bitcoin, Ether, the idea is you couldn't write to Bitcoin and get things frozen or ask for help. That is slightly different to centralized cryptocurrencies, which are operated by a centralized entity. For instance, Tether, Bitcoin, Binance Coin. Binance Coin is obviously operated by Binance. Very briefly then, an overview of what digital assets are, and then I'll sort of start my story. I've gone through cryptocurrencies. The idea is they're fungible. So if I take a £20 note and swap it for Brian's £20 note, I'm not going to care that I've got a different £20 note. The idea is you can trade one for one. Tokens broadly are tokens on a blockchain. It's very bad to use a definition with the word in, but it's quite a helpful idea. So, for instance, you can have a DAO, a decentralized autonomous organization that hands out tokens for people. Those NFTs that you saw, which are below with those apes, they are essentially tokens. You can have meme coins. I've recently put that in after Trump released his meme coin. Whether that's questionable or not is probably under a completely different talk. But it's of no real, meme coins, no real value. They're just to promote a meme or a project or a sense of things. NFTs are the very opposite in the sense of fungibility of cryptocurrencies. It essentially means one cannot be traded for another alike. So there were the Bored Apes is a good example there with these sort of types of artwork that in theory couldn't be traded one for one on the blockchain because they had a cryptographic hash that couldn't be replicated. Stable coins on the top right. They are designed, keyword there, designed to hold the same value as fiat money. Examples of that are Tether, where it's supposed to be tethered to the dollar. Britain is thinking about a Britcoin, a stable coin designed to the pound, and we'll come on to that shortly afterwards. Security tokens. Security tokens are tokens which have a kind of financial product within them. So there's Financial Service and Markets Act, and that deals with definitions of how you can deal with certain assets. And security tokens fall under that. It basically says that you can't sell them to the open market without certain permissions. So for instance, stocks and bonds, and if you were to tokenize those, it could be problematic if you didn't get the right permissions. At the very bottom right is essentially it's stable coins, but it's backed by the government. So as I said earlier about Britcoins, a central bank digital currency may well be a pound issued by the Bank of England. So those are a few examples of what digital assets or cryptocurrencies may be. But now to the fun bit, which is the storytelling, and you're going to see me turn the pages of some notes whilst I go through this. So bear with me, because there's quite a lot of it. Okay, so this was a case I worked on in 2019. And what had happened is a hospital fell victim to a ransomware attack. We think one of the workers clicked on a phishing link and all the data disappeared. They were locked out, and on the screen there was all the screens in the hospital. The hackers put a message, and it read, "Hello, insured customer. Your network was hacked and encrypted. No free decryption software is available on the web. Email us at," and I'm not going to give away the email address, "to get the ransom amount. Please keep our contacts safe. Disclosure can lead to an impossibility of decryption. Please use your company name as the email subject." Clearly, they're doing this a lot. And then another following message, "Hello. To get your data back, you have to pay for the decryption tool. The price is $1.2 million. You make this payment in Bitcoins." So that's why we ended up in a difficult situation, because the client, the Canadian hospital were locked out of their systems and had to pay 1.2 million in Bitcoin. After some negotiation between the parties, it was dropped to $950,000. And they said, "You can send us a few encrypted files to test for the decryption." So it's all very nice and gentlemanly, despite the fact that they were hacked. The ransom was paid by an insurer in London. The umbrella symbol there is supposed to symbolize an insurance company. The insurance base in London paid the ransom on the 10th of October 2019. And the tool was therefore received shortly afterwards, and the hospital got their data back. So in that respect, crisis averted. Not really common to be paying ransoms, but it does happen and people do get stuck. And ultimately, there is a business model that allows, I'm blind in my notes, that allows funds to be recovered. We traced those funds along the blockchain. So we found that the 96 Bitcoin paid had gone to Bitfinex in the BVI. So you're able to follow the funds paid along the relevant blockchain. Here it was Bitcoin. And we saw that they were deposited at an exchange called Bitfinex. And we asked for help. Now, this was the first time this had properly been considered at court, and we relied on a company called Chainalysis, which I've highlighted in orange there. Now, what Chainalysis did is they provided, in this instance, a report to show that the funds had moved from our insurer's wallet address and moved all the way across to Bitfinex. And I think the other day, Rob Moore and Scott Pounder did a demonstration of what these reports look like. But what I have to do is I have to obtain a tracing report from an investigator like Rob or Scott to see where the funds have gone. And they broadly look like this. This is just a random example over the years that I've collected. So you can see that the victim in this instance was had a Binance account, and they moved 1.56 Bitcoin to the suspect's wallet, and then it was moved to FixFloat and OKX. And in our example, in the case that I was working on, it started in their own private wallet and it ended up at Bitfinex. So you can see this is a very, very simple diagram of how this works. So we've got our evidence and we want to try and get the funds back. So we go to court, and I'm going to explain how we do this very briefly. So let's take the right-hand side of the screen. We're armed now with a report to show that the funds have gone to Bitfinex. We create a set of defendants, and in England at least, you can have defendants called persons unknown. It's a jurisdiction that allows you to sue people you don't know the identity of yet, but they can be served papers. So we know that they have an email address, or we know that they have a physical address, or most recently and most helpfully, we know that they have a crypto address, and we can serve them via NFT. I'll come to that. But we describe them as, the first is defendant one. Defendant one is the bad actor. So in the instance of the hospital, it was the person who stole those Bitcoin, or sorry, not stole them, who demanded them. So D1, essentially the bad actor, the person who created the misappropriation. And when we follow the assets, we can see that they go to Bitfinex. We don't want to sue Bitfinex. We want Bitfinex's help. But category 2 defendant is the party who ended up with the funds, i.e. they are Bitfinex's customer. They are part of, in almost all cases I've worked on, the fraud. So defendant 1, person who stole. Defendant 2, person who ended up with the money. And we know that they ended up with the money because it's been traced on the blockchain. The reason we stop there is because Bitfinex, or any crypto exchange that is worth its weight in well, anything, should be doing KYC, and we are able to identify from them their customers' information, and that's how we sue them. There was a case where the judge tried to introduce a defendant 3, persons unknown, for what's called bona fide purchasers. The idea here is, if you were a defendant 2 and you were completely innocent and you had no idea that the funds that you had received were stolen, this new category 3 would be relevant. You'd fall under that. And I'll go through why that was, in my view, utterly unhelpful as we go forward. And then defendant 4, or they're not really defendants, they are parties which we are seeking help, parties mixed up in the wrongdoing, are the exchanges. And in this instance, it was Bitfinex. Now, in cases that I've worked on, including when I was in court on Wednesday, getting an injunction on a case very similar to this, you seek the exchange's help. So as soon as you have a report, you write to them and let them know that they've received the proceeds of crime, and that they need to do certain things with those assets, include not move them, not convert them, not allow any liquidations, and to provide us with disclosure, who their customer is, transaction identifiers. Most of the time they say, we're happy to do that, but we need a court order. So then we move to the left of the screen. So we know who our parties are, and we apply for, hopefully, anonymity. Hopefully we get that. What that means is we do it without anybody else. Anonymity is changing the name of the victim, because sometimes this can be quite stressful. I've had cases where people have been defrauded through dating apps, and actually the whole story can be quite embarrassing and quite difficult to overcome. So you can change the name of the defendant. In this case, AA and persons unknown. AA was a party, and we anonymized them for their own safety. Number 2 is privacy. We apply to have it in private. Open justice means that anybody essentially can walk into a courtroom and see what's going on. We're saying in that instance, we want to deviate from that rule on the basis that we don't want any of the defendants to know what we're doing, because if they do, they may move the money. The third thing that we're going for is what's called a proprietary injunction. Proprietary means property, and injunction means an order to do or not do something. So in this instance, we want all of the parties to freeze the funds. So we can see that the Bitcoin in the case that we were referring to needs to be frozen. And there is a test for obtaining a proprietary injunction, which I'm going to read out because it is important. Bearing in mind, this is an injunction over the property, and I'll tell you why that's important. But anyway, the test for a proprietary injunction is there is a serious issue to be tried against the first and or second defendant. So, for example, arguments like deceit, unjust enrichment, there has to be a substantive claim against them. Criteria 2, damages would not be an adequate remedy, i.e. there is a strong likelihood that the defendants would not pay damages even if you got a judgment against them. And having engaged, for example, they've engaged in unlawful activity, and this example, obviously, they are probably not going to turn up to court and say, yes, I'll pay you damages. And the third test is quite an odd concept at law. It's called the balance of convenience. That is, the respective inconvenience or loss to each party is granted or not and considered. So would it be convenient, given the status, to grant a proprietary injunction? And that is a really important test that we'll come to. But we are freezing the assets traced. Number 4 is the most draconian measure. And what we're doing is we're seeking a worldwide freezing injunction over the first and second defendants. What that means is we calculate what the value of the lost Bitcoin, on our example, 1.2 mil, or I think it got down to $950,000 worth of Bitcoin. And we freeze all of their assets up to that value around the world. Now, that is a super draconian and quite scary thing to have served on you. You are given an allowance normally of about £500 a week. That's London. If it's around the world, it'd be different. But
Sorry, Matt, bear with me. Let me just mute everybody and then you unmute yourself, okay?
Sure.
Okay, Matt, just unmute yourself, please.
Sure.
All
So
right.
it means that all of your assets are frozen. So even if the Bitcoin in this case had been traced to Bitfinex and then cashed out, we're still entitled under the worldwide freezer, under that safety net, to get any assets that popped out the other side. And the last thing we apply for is disclosure against the exchanges to see who their customers are. Now, the case that we had last week, we had some of the parties who claimed that they are a non-custodial and simply swap tokens for tokens. Change now, simple swap. We still managed to get disclosure, and we still found out email addresses and relevant parties. In essence, then, there is no way to hide around these things. And even if, well, a good example was the Bybit hack that occurred recently. If it had occurred in the UK, my sense is we would have had quite a different outcome. But anyway, these are the applications we make to court to freeze funds, and there is normally no escape from identifying the wrongdoers. Oh, bear with me. Okay. I was talking about the proprietary injunction. The problem with a proprietary injunction is that under English law, property is limited by definition. So there is a chap called Lord Wilberforce. He had a definition in 1965 which said it must be definable. So this is the definition of property. Must be definable, identifiable by third parties, capable in their nature of being assumed by third parties, and having some degree of permanence. Now, there was a legal statement. There was a legal statement from the UK Jurisdictional Task Force on the 11th of November 2019 called Crypto Assets and Smart Contracts. And it had its own view of Ainsworth. It also had its own view of what is the normal definition of property, which is a chosen possession or a chosen action, which are very strange words for essentially saying tangible things that I can hold. My mug, for example, can be property, or a legal right to something like a debt. So chosen action, debt, and possession, something tangible. And the legal statement said, we think this needs redefining. In fact, paragraph 15 says, however, crypto assets have all the indicia of property. They are novel or distinct, or they have distinctive features. Crypto assets have all the indicia of property. The novel or distinctive features possessed by some crypto assets, intangibility, cryptographic authentication, use of a distributed transaction ledger, decentralization, rule by consensus, do not disqualify them from being property. Nor are they crypto assets disqualified from being property as pure information, or because they may not be classifiable either as things in possession or things in action. You're going to hear this not definable by possession, by things in action a lot over the course of this session. In theory, then, that paper said crypto assets could be treated as property. There was no, however, definition that they should be. So we went to court and we relied on that statement. We relied on that paper to see how we could make crypto assets property to apply a proprietary injunction. However, there was a case before us. To give background on this case, it's a case called Robertson and Persons Unknown. The claimant in this case was the victim of a spear phishing attack, which targeted an email account of a tech startup that had been investing using Bitcoin. As a result, the claimant transferred 100 Bitcoin to the fraudster's wallet, following which 80 of those Bitcoin were transferred to the fraudster to a wallet at Coinbase. The idea was the assets were not traded, so they were not swapped. And therefore, the 80 Bitcoin that was stolen were the same ones that had ended up at the exchange. In that instance, they applied for a freezing order against the Persons Unknown, so the worldwide freezer. But instead of a proprietary injunction, they applied for what's called an asset preservation order. Because they were the same Bitcoin that was stolen, what they wanted to do was simply ask to freeze those exact assets, freeze those assets, preserve those assets. So the issue around whether crypto assets were property was never considered in that case. And I'm very lucky they weren't, because the case that I worked on made some cool law. So although they gave it a go, it didn't have the same effect. So crypto assets become property at law under this case, AA Persons Unknown. So the issue of property was considered substantively, looking at the definitions of the historical definitions of property, and the UK's task force legal paper was incredibly helpful. So paragraph 59 of this judgment, A, Persons Unknown, I've read this out so many times, it's great. It says, I consider that crypto asset, such as Bitcoin, are property. Amazing. They meet the 4 criteria set out in Wilberforce's classic definition, which we covered earlier, as being definable, identifiable by third parties, capable in their nature of assumption by third parties, and having some degree of permanence. So what it is doing, it's looking at the old law and considering that a new kind of property can apply. Paragraph 61 of that judgment also notes, in those circumstances, and for the reason I have given, as elaborated on in the legal statement, which we've covered, I gratefully consider to be an accurate statement of the position of English law. I'm satisfied for the purposes of granting an interim injunction our proprietary injunction in the form of a proprietary injunction that cryptocurrencies are a form of property capable of being the subject of a proprietary injunction. Very wordy, but essentially what it means is crypto assets can be property, and therefore a proprietary injunction can apply to them. Now, this was the starting place, essentially academically, for how we treat crypto assets today. And it means that they are property. Now, why on earth do we care is probably the next question. The reason we care is because you can have personal rights now against crypto assets. So if someone stole them, you have a right to get them back. You can enforce against them. You can obtain injunctions to protect your assets. It also means that there's more confidence in the market, because if someone steals your assets and you're able to get them back, or you're able to identify them and claim them as yours, people are more likely to buy them. And of course, you can enforce against third parties. If Brian stole my Bitcoin, I would be able to say, that is mine, it's my property, and I want it from you. So what happened next? This is the bit that Brian helped me out with many years ago when we were putting this list together. And I'm going to run through some of the important case law and what on earth happened next. So let's run through it. I'm not going to go through all of it because it is a lot, but some of these cases are really helpful in demonstrating the process of asset recovery of crypto assets. So let's start at the top. There's a case called Toma and Murray. It was an early case I worked on back in 2020. It says that you cannot get an interim injunction over Bitcoin where damages would be an adequate remedy. Do you remember, you can only get an injunction where damages are not an adequate remedy. In that case, Toma and Murray knew each other. It wasn't a persons unknown case, and Murray could have provided Toma with damages, and therefore it shouldn't apply. An injunction like that shouldn't apply. Rusco in New Zealand, it was a New Zealand case. The court held that cryptocurrencies, like digital assets, are a form of property that are capable of being held on trust. So again, it reinforces the decision in AA. It's an important decision, as it's one of only a few in common law world to address expressly the question in a fully reasoned judgment as to whether digital assets such as cryptocurrencies constitute property and can be the subject of a trust, which is an enormously important thing when there is fraud. Because if your assets have been taken away from you, the person who stole them are essentially holding them on trust for you and owe you those funds. Number 3 was a case called Mr. Dollar Bill. I don't know why he named it that company, but he did. It was another case I worked on in 2021. Remember when we went to court earlier and we were looking to get disclosure? Essentially, this case said that you can get what's called Norwich Pharmacal orders, which is a type of mechanism that allows you to get disclosures from third parties. It's okay to use against defendants located outside the jurisdictions. Now, you think about it, most of the crypto exchanges are in the BVI, as we discussed, or Seychelles, or maybe even nowhere. So it's a useful tool to be able to get disclosure. Number 5, I'm going to skip to number 5 because it's still reported widely, used widely today. Ion Science considers the place, well, it's the Lex Citus, which is essentially where a crypto asset, is the Lex Citus of a crypto asset is the place where the person or company who owns it is domiciled. So, sorry, that was very poorly expressed. But what it means is if you're trying to find a jurisdiction for, say, a dispute, or to find out where those assets are, because they are online and are supposed to be decentralized, the idea is the Lex Citus, the location of those assets, is where that individual is domiciled. Now, last Wednesday when I was in court, that's exactly what we had to discuss. The individual spent a lot of time in Spain, even though he was an English citizen and a passport holder. And the idea of locating the Lex Citus of those assets was important to try and obtain jurisdiction over that claim. So in that respect, the Lex Citus and that case is extremely important. Where are those assets? And it's normally where they are domiciled. Fetch AI was a decision which includes persons unknown as a subcategory. Do you remember a little earlier? I'm going to try and flick back to it. I said there on the right-hand side, D3, bona fide purchasers, new language. What happened was in this claim was the judge in this instance said, if you're a bona fide purchaser, which is essentially, I had no idea that these assets were stolen and I have obtained them. It's the idea that an old lady might have bought a stolen car, as long as she had no idea and she paid market value, those assets are hers. She gets to keep the car. And that's the idea here. So the judge introduced a category 3 bona fide purchaser. The problem with that is when we served the documents on our defendants, they immediately said, I'm innocent. I fall under this category. Thanks. Nothing applies to us. So it actually wasn't enormously helpful. So what we had to then do was draft some wording to say recipients of the funds who are bona fide purchasers and can prove that they are bona fide purchasers, which stops then people automatically assuming that they're innocent. They have to prove that they came across these assets innocently. So that wasn't a very helpful case, if I'm honest, but still very important to discuss. Number seven was tulip trading. So this was a case whereby an individual called Craig Wright, whom people may or may not know, who was essentially the spokesperson for tulip trading, which was a trust entity. That trust entity had lost, or in theory, Craig had lost a lot of money, seemingly billions of pounds worth of Bitcoin, by what he claimed was a theft, stealing of data in his home. And he asked, because Bitcoin is decentralized, as I said earlier, and therefore you can't write to Bitcoin and ask them to freeze, he sought to sue the operators of the Bitcoin system so that he could, or they could, be compelled to change the code and allow him to re-access his funds. So because the data was stolen, the assets behind the system, as it were, held in the address via the private key, they couldn't be moved. The private key was stolen, the seed phrases were stolen, they were gone. And he wanted the Bitcoin Association to change the code to allow those assets to be moved or to be destroyed and reallocated elsewhere that were in his control. The reason that was controversial was because it created a duty for coders and people creating software if he was successful. So imagine you're at home and you're creating some software and it causes loss to somebody in 10 years' time and there's a level of remoteness. In this case, he said, well, actually, you have a duty. You have a duty if you create something that is a software. And that was hugely contentious and was discontinued last year. I was leading on that case when it got discontinued at the end of last year, but hugely interesting. And I'll come on to why that's an important case in terms of defining property or crypto assets as property. The case of Danzig at the bottom, which you can sort of half see, another case concerning the loss of crypto assets, and it expressly confirmed the need to act quickly in fraud cases. There is a quote within this judgment that every judge now uses, and they get very, very excited about using this phrase. It says, this is a form of transaction whereby at the click of a mouse, an asset can be dissipated. And judges find that very exciting for some reason, because it involves the click of a mouse. But the idea is you need to move super quick because these assets can fly. And even if they do fly off, you can still make recoveries, but it's prudent to act quickly. Now, that judgment also explicitly reconfirmed that crypto assets are property, referring explicitly to AA persons unknown. Let me have a look here. Okay, yes, the next one was Osborne. So I think Lavinia Osborne came and spoke to you guys, didn't she, Brian? I think.
Yeah, she was here last week. Yeah, Lavinia.
So that is that Lavinia. And she had lost some NFTs. I think they were called Boss Babes. Is that right?
Boss Babes. Like it wasn't Crypto Kitties, was it? No.
No, it wasn't Crypto Kitties. Boss Babes.
Yeah.
Someone had stolen her Boss Babes, and she did something very similar, like we did with AA Persons Unknown. And the judge confirmed that non-fungible tokens were property, quote, for present purposes. And I'll quote from the judgment. He noted that there was clearly going to be an issue at some stage as to whether non-fungible tokens constitute property for the purposes of law of England and Wales. I don't really understand why he said that, because the judgment in AA said cryptocurrencies. Now, I suppose if you want to be difficult, they're not necessarily currencies, but it's broadly the same technology. These kinds of assets on our blockchain can be property. the quote from AA is, I consider that a crypto asset. No, in fact, I'm wrong. It says on the judgment AA, a crypto asset. So again, I'm not entirely sure why the judge decided to sort of differentiate, because it all falls under that umbrella. But of course, it was very exciting at the time to see that non-fungible tokens could also in their right be property, even though to me, they were. Number 10 was really interesting. It was a case called Fabrizio De Loya, where I think they'd lost, I think it was about $840,000 worth of tether. Now, that case finished last year, but at that time, back in 2022, they served the documents via NFT. Now, what the hell does that mean? Normally, when you have a claim, you have to serve the documents on somebody to make sure that they know that they're being sued or aware of an order. And you normally do it by email or by leaving it at someone's door. The rules in England even allow you to do it by fax. This was the first case where you could serve documents via NFT, which is enormously helpful in circumstances where you have no other information other than you know that the fraudster or the wrongdoer used a crypto address. So in the first case, let's have a look. If I go back here, you can see that this suspect's wallet used this account, and we would be able to serve the first defendant using this address. So it's enormously helpful. And what you do is you serve them with an NFT, which is a lawyer's letter, which includes a link within. And if you click on that link, all of the court documents are within. And that is now deemed as good practice and good service. I'm going to skip a few which are less interesting and move to number 13.
But Matt,
Gary.
in terms of serving using an NFT,
Yeah,
there's some repercussions in terms of IP and
yeah, it's a good point. So that information, or that the composition of the NFT is going to be there in theory forever. So what you want to do is be very careful as to what you put on your NFT. We use a lawyer's letter. We don't mind using a lawyer's letter. It's got our headed paper. But what you don't want to necessarily do is use wildly confidential information, or you need to be very careful of intellectual property that is essentially going to be stuck on this blockchain forever. That's why we use a link, so that we can change the data room that link sends things to make sure that we can keep, it's like an inbox that we can keep it updated. But it has its pros and it has its cons. The more I've used it, the more I liked it. I think, Brian, I was quite critical of it at the start, because I think the first time it was done, the NFT was a picture of the crown seal.
yeah.
And of course, that would be copyright infringement, because you don't have rights to reproduce that.
Yeah.
But things have moved on since then. When I do this, we use a lawyer's letter.
Okay.
To avoid that. Number 13, I'm going to skip ahead a little bit, because the 11 and 12 are relatively interesting, but not interesting, for me at least anyway. Number 13 was a case called Gary Jones. Again, someone lost some money. The following, well, it was actually 89 Bitcoin, which is obviously a lot nowadays. The judge found that tracing those assets in equity will create a constructive trust. So we spoke about the New Zealand case earlier. In this instance, it was considered in the UK, well, certainly in England, and the victim had a proprietary interest in those funds. Again, hugely useful legal tool to be able to say that you are owed money held on trust. Number 14 is probably one of my favorite cases. Really, I was annoyed that I didn't get to do this myself, to be honest. It's a really great tool. So what happens is if you go back, we write to a hack occurs, or a theft, whatever it may be. We get a short report to say your money has gone to whichever crypto exchange. We write to the crypto exchange and we say, please identify who runs, operates, and/or controls your exchange, because we need disclosure from you. They fail to do so. They may have in their terms and conditions, we are company XYZ and we're in the BVI, or we're in Grenadines, but you never really know who operates them. This case here avoided all that. It was a case involving Binance, because it wasn't clear who was operating Binance. So what they did is they said, okay, we sue defendant 1, persons unknown who stole. We sue defendant 2, persons unknown who ended up with the money. And now we're going to include you, Binance, as a persons unknown who operate, control, and manage Binance. Because what can happen is if you sue one Binance entity, you might get the wrong one. Or what's happened, and I've seen this before, is one company is sued and then they change which company does an operation. whether they hold, it may be that another company holds the funds or is able to do, I don't know, marketing, and you just end up choosing the wrong one. So what this does, it's like a safety net to say, we don't care who you are, all of you are captured. Whoever operates, manages, and or controls Binance, Kraken, Coinbase, HitBTC, Huobi, whoever it may be, you're not getting away with it. So it's a really useful tool. I was using this case last week. It was really, really smart. And a great way to avoid exchanges saying that they're decentralized and no one runs them. Well, someone's got to run it. I'm just running through my notes.
Matt, quick question. Are you going to discuss Pirazude in terms of exchange liability?
Brian.
All right. Oh, okay, cool.
Okay. So the next case was Pirazude, which happened last year. It was last year. The victim here, Pirazude, lost $870,818 worth of tether to wallets controlled by fraudsters. The claimant obtained the relevant injunctions but did not tell Binance where the funds ended up and where the funds were traced to. At the return date, Binance turned up to seek to discharge those injunctions. So what happens is we as I was explaining before with the applications, you go to court and you do it without notice. So I normally tell the exchanges, in this case Binance, I would say, hey Binance, you've received the proceeds of crime, here's what you need to do. We ask for your help. In this instance, they didn't do that. They went straight away and sued Binance. I don't know why, but they accused Binance of wrongdoing. I don't know why. I don't know what Binance have done here. You sue them, you get your orders, you serve it upon them, and then you have what's called a return date. Because you did it without notice, i.e. they had no notice of the hearing. The return date allows any parties to turn up to court and say, hey, I didn't have any notice of this, and yes, I've got this order, but I want to challenge it. And Binance did that at the return date. So where was I? At the return date, Binance turned up to seek to discharge those injunctions. And Trower, who was the judge, discharged the injunctions on the grounds that the claimant's representatives had breached their duty of fair representation in obtaining the injunction. He ordered, this was terrible, he ordered that the claimant to pay the costs of an indemnity basis. So normally, if you lose, you pay about 50 to 65% of damages. If you've done something wrong, like in this case, it's called indemnity, and it can be 70, 80, 90, whatever it is. It's a real punch in the gut. So what on earth happened? There was a few things that happened. Number one, Binance in the terms and conditions say that money sent to them is pooled. It's pooled together in a big customer fund, and therefore a proprietary injunction can't really exist. Now, I have my own views on that, which I won't discuss here. But essentially, if the lawyers had known that, they should have changed their application at court. They didn't. They just flew straight in. We want a proprietary injunction. So the proprietary injunction was discharged essentially because it was frustrated. Secondly, the claimant stated jurisdiction for making the application without notice, including not telling Binance, failed to distinguish between the position of different defendants. The claimant believed that Binance had done something wrong and did not write to them before starting the claim. The claimant treated them as a party to the fraud without any evidence, which was a significant failing. Remember, step one of the proprietary injunction, there is a serious issue to be tried against the defendants. Examples, deceit or unjust enrichment. These guys, there wasn't anything. There was no substantive claim at all against Binance. The obvious solution in the situation was for the claimant to proceed without notice against the fraudsters, but not against Binance. So it was a little bit painful to see an application made that hadn't particularly been thought out well enough. Now, the other problem really is when you make an ex parte or without notice application, there is this idea of full and frank disclosure or fair representation, where you need to, in evidence, say the other party's not here today in court. So what we're going to do is we're going to provide you with potential defenses that the other party may raise to allow the judge to make a more informed decision as what he or she wants to do. So making an ex parte application, you need to ensure that the court is given a full and frank disclosure, including potential defenses that the other party who are not present may argue. In arguing for a constructive trust, which they did, the claimant had failed to explain the defense of a bona fide purchaser, which we went through earlier. They absolutely needed to tell the judge that there was a potential defense of bona fide purchaser. They also didn't talk about any segregated funds or any potential existence of pooling. So they failed to get their, well, they originally got their injunction and they had it immediately discharged at the return date because of very basic failings at law. They should have done a much better job, if I'm being very, very frank. So that was a bit of a car crash last year. The next case was a case called Bunyang, which I hope I'm saying right. Now, this case involved a very, very similar set of circumstances, and they served the claim against D1 and D2. If you remember, the fraudster, the person who stole the money, and D2, the persons who ended up with the money. But there was a problem later down the line. Sorry. They served everybody. They sought for default judgment. And default judgment essentially says that they've been timed out. You had X number of days for a defense, and you didn't file your defense in time, so you automatically win. I also believe they sought a summary judgment, which is the defendants don't really have any reasonable prospect of defending it, so you win. So you got default judgment, summary judgment. They failed to get the final judgments here, and I'll explain why. There's 2 points broadly. Firstly, well, I suppose point one is that the judge noted again that crypto assets were property and referred to a persons unknown and the UK jurisdictional task force. But point two was one of the defendants could not be established. They could not be served. I'll read from my notes. The disclosure order made by the judge produced no useful results in service. It had not assisted in identifying the persons who perpetrated the fraud on the claim. In these instances, D1, the first defendant, the fraudster, did not describe any person who could be served the documents. Now, there is a weird claim. Well, it's not weird. It was a good reference to make, but it was all to do with a. Let me have a look. It was to do with a hit and run claim. The idea being that if you were trying to sue somebody who committed a hit and run car accident, so to speak, against you, in theory, you go, well, I have persons unknown, and I'll find out who they are later. But without any evidence, you have no idea who they are, and you will never, ever be able to find out who this person is. You'll never be able to find serve court documents on you. And the way this case was built was they were unable to serve the first defendant, and therefore they were not able to get default judgment or summary judgment against that defendant because they could never be served. Now, if they were a little bit smarter, they could have served them via NFT because, of course, at some point someone had to pay money to somebody. They didn't, and I don't know why, but there was clearly an issue around service, which was frustrating. And then, of course, the last one, I don't know what happened to 13, 14, and 15, but they disappeared. But the last one, and this is a really quite important judgment, which occurred at the end of last year, was the case I referred to before, Fabrizio De Lawyer. And again, he lost, what was it, $817,000 or $14,000 worth of tether. The reason this made legal headlines last year was because De Lawyer, the victim, sued BitCub. So the funds, amongst other places, had been sent to BitCub, which is a Thai cryptocurrency exchange. And the same team as Perusido also sued on the basis that there was wrongdoing BitCub. So the money had been sent to BitCub's customer, who I would sue, and then also sent to BitCub, and they sued BitCub. Now, the problem is the investigator in this claim could not, to the judge's satisfaction in the report, show that the money that had been received by the customer of BitCub, the money launderer, and it was established that they were a money launderer in the judgment. It wasn't shown that that customer had sent that money to BitCub. And there was a lot of criticism of the investigator, which I think was unfortunate because, number one, no expert evidence in a substantive case had really been considered by a judge. And number two, the lawyers should have noted that where commingling occurs, i.e. my money along with Brian's money, and it pops out and we don't know who it is, may defeat a proprietary claim, which they saw, although it wouldn't necessarily stop a personal claim. But that actually BitCub didn't need to be sued at all. There was no reason to pursue them for any wrongdoing. It made the headlines because it was a car crash. And it was unfortunate for the lawyers, it was unfortunate for the investigator, and it was entirely avoidable. Now, I prepared an article for Thomson Reuters, which there is a link below. Brian, did we do that together? Was that another one we did together? No.
Yeah,
That's
the one.
We did this one together?
Yeah.
Where we essentially considered that actually the lawyers had produced a bad strategy rather than the investigator failing to do his bit, which was enormously unfair. But anyway, that is a summary of the case law. There are other cases, and there's lots of ongoing cases that I personally have that I'm not allowed to talk about currently because they are in private. Legislative changes are next. So what happened? We had all the case law, and then the legislation kicks in. And the Law Commission got involved and considered whether crypto assets or digital assets could be property. And they produced a report, an initial report about what this all meant. And they said, we suggested explicitly recognizing a third category of personal property, i.e. things that are not tangible and not a legal right, would be a useful development in law because it would allow for a more nuanced consideration of new, emergent, and idiosyncratic things. It would allow the law to develop by analogy with things in possession or things in action, where appropriate, whilst also recognizing that certain things do not fall neatly within either category. A distinct third category would better allow the law to focus on attributes or characteristics of things in question without being fettered by analysis or principles applicable to the objects of personal property rights. So the Law Commission has looked at a persons unknown, it's looked at the Osborne case and the various other ones we spoke about, and it decided that it wanted to intervene and consider whether case law as it was suitable or whether they needed to do something else. And they came up with a recommendation to create a third category of property, which was essentially designed as follows. It had three criteria, which are on screen. You can see 1, 2, 3. Number one, it was to be data represented in an electronic medium, i.e. things that are not tangible, things that cannot be held. Things like a data stick or a hard drive is a thing in possession, but the data within it would be falling under this new category. The second criteria is that unlike a chosen action, which exists where there is a legal system where you can enforce rights, there didn't need to be any in this case. So it exists independently of a person or a legal system. It exists outside of human beings. So the first category is outside of things in possession. The second category is outside things in chose. And the last thing, and I'm going to read from it because it is quite a useful analogy, is be rivalrous. So this means that the use by one person of the data object prevents another from using it. The Commission uses the example of a book. For example, Alice spends her lunchtime reading the book Pokemon, The Electronic Tale of Pikachu. Why they've chose Pokemon, I quite like, which does not necessarily preclude Bob from reading the same story. Of course, Bob's copy of the book will be different as a physical object to Alice's, and the physical books themselves will be rivalrous objects, but the story itself, the narrative, the information recorded in both copies will be the same. That information is not rivalrous. Alice's consumption of it does not prejudice Bob's ability to consume it. So this would apply to crypto assets in as much as a person may hold a crypto asset and that use of it prevents someone else from using it as a basic premise. So there were several papers that went back and forth, and the Law Commission went to the legal industry and various other industry players and considered what they could do to update this. For me, there are three main points here, and you can see some of their recommendations on screen. Firstly, point one, they're letting common law set the precedents and boundaries of how jurisdiction treats digital assets. They say in this here, I'll highlight it. First, we conclude that the common law, i.e. case law, like the case law we ran through, of England and Wales is in general sufficiently flexible and already able to accommodate digital assets, i.e. will let the courts make the law. But really, point 2 was about data objects. They say in their paper, we want to be avoiding defining hard boundaries of third category of thing. We recommend a statutory confirmation, and this is alluding to the next step, that a thing will not be deprived of legal status as an object of personal property rights merely by reason of the fact that it is neither a thing in action or a thing in possession. However, we conclude that it is not necessary or appropriate to define in statute the hard boundaries of such a third thing. We conclude that the common law is a better vehicle for determining those things that property can and should be objects of personal property rights. It is a weird thing, in my view, to say. I'm going to read it again. It is not necessary. Well, I'll come on to the next screen, but it's like a triple negative, and it's started the draft of a piece of legislation. Anyway, the third point that they made in their final paper was these are no longer criteria. These three things on screen, they're now indicia, so they don't have to all be met for something to be considered property. Which leads us to where we are now. So this wording here that I was reading about, things won't be deprived of, was actually pulled out of the Law Commission and was recommended as a drafted bill that was put before the UK Parliament. And the wording of that bill, if anybody understands this, you're far smarter than me. Okay, so please bear that in mind. I think this is what the law is currently drafted as, and it's gone through the House of Lords. A thing, including a thing that is digital or electronic in nature, is not prevented from being the object of personal property rights merely because it is neither a thing in possession or a thing in action. Pause for confusion. So I was lucky enough to be invited to the House of Lords to give my view of this piece of legislation, and I've put a link there if anybody has any time to read the wording that I put to them. But essentially my views of this are, number one, you said common law was going to be the most important thing. Common law is generally flexible. Why do we need a piece of law like this? And number two, it's confusing. And if we pass it, it may well be confusing. And if we don't pass it, it doesn't give us as a jurisdiction a very good light. It makes us look like we are not prepared to pass law that helps with the integration of digital assets. So we've made it very difficult for ourselves to show via legislation that we are serious about this. Now, I spoke to the Law Commissioner who drafted this paper and asked her about this piece of legislation. And what she said to me was actually very helpful. She said, whenever a judge gets a case like yours, Matt, where someone asks for a proprietary injunction, or someone asks for a judge to exercise property rights over digital assets, whether it's cryptocurrencies, carbon credits, whether it's some asset we've not even dreamt of yet, the judiciary get nervous because the law, the hard law, is here. That's technically where we are, 1965. And despite our papers, that is technically where the law is. So what the bill was designed to allow a judge to rely on some relatively woolly language so that they were not deprived of making things property, which does make sense. They didn't want to bend the rules. They wanted to allow legislation or to be given permission via legislation to make things property, even where they didn't neatly fall into either. But whether that wording is suitable or not, I'm not entirely sure. However, that case of Tulip Trading we were talking about before makes explicit reference to the consultation paper of the Law Commission, which we've discussed, the National Provisional Bank of Ainsworth, that's what we were talking about before with the definition from 1965. And at the end, it says, as Brian J. held in AA Persons Unknown, a crypto asset such as Bitcoin is property. Now, why do I bring that up now? This case was in the Court of Appeal. So it went from the High Court to the Court of Appeal, the only court higher than that, the Supreme Court. When a decision is made in the Court of Appeal, it is usually considered very good law. So for us to be debating whether crypto assets, digital assets, a new third category of assets, we've already got a position. It's already in a very high court, in the Court of Appeal. So my personal view is, and I'm open to changing it, is we didn't really need a piece of confusing legislation. And in fact, the Law Commission already said that. The Law Commission already said that common law is sufficient. That is our common law. And it says crypto assets such as Bitcoin are property. So a little bit frustrating, but that is essentially the story of how crypto assets, digital assets, became property, all the way from case law, where we were trying to recover Bitcoin, through to where we are with a draft legislative bill. However, what's necessarily next? I was in court last year where we were trying to get default judgments, and some of the judges were concerned about where you were trying to pursue persons unknown. I'm not going to go too much into it. It's definitely worth reviewing some of these cases, but it was at the very end of the process of recovery where they said, well, if we still don't know exactly their identity, how can we get judgments against them? And my argument is, so long as we can serve them, as long as they've got assets, we should be good. The other point to raise is whether and to what extent we can, or as litigators like me, can work with the police under the new Proceeds of Crime Act rules. There was a case as of last week. A friend of mine in the industry used the new Proceeds of Crime Act in conjunction with a friendly police officer to obtain a recovery of, I think, about £580,000 following a scam. So there's still lots of work to do, and it's always not easy, but it is excellent fun. For reference, certainly from my experience, I've obtained funds that were stolen, worked on cases where we sued, we included as D1 Lazarus, who were the North Korean hackers, which was pretty cool. We got funds back from for a client where the funds ended up in an organ harvesting facility in Myanmar. We had a look at the Google reviews of this location, and people said that they were waking up without kidneys, which was pretty crazy. But in these instances, you can still get their money back because you go after not only the bad actor, but the individuals who ended up with the money, who were part of the criminal gang. So in every instance, we can always uncover who these individuals are. We currently have a claim where we are getting information from the exchanges, and everyone seems to be in Nigeria. So for any parties in Nigeria, unfortunately, we can still see who these people are. I'll let Scott on there. But any questions? I can see that there are some in the chat. Brian, if you want to allow me to answer some of them.
So I had a question for myself. So Matt, what does all this mean for the entrepreneurs and the students and the startups and people in this boot camp? If you're to just wrap it all up, what does this mean for them?
It means that because crypto assets are property, it means that you are now investing your time and energy into an asset class that has momentum and that has property rights. So this isn't just necessarily magic internet money anymore. This is stuff that people care about, that are adequately protected under at least the laws of England and Wales, and that require careful thought when things get lost. But it is a hugely positive step in the right direction.
Okay. Matt, if you want to stop sharing your screen, I'm going to ask these other questions as well. I just want to pin the other panelists on the...
Can I ask a question while you're doing that, Brian? If that's it. Matt, thank you for so much of that. I thought that was a fantastic presentation, actually. Really, really useful. I've got a couple of questions, but I don't want to take up too much time. So a general one that I do have is, to what extent do you need to to what extent do you need to be concerned, for example, if when you're initiating a person's unknown application, to what extent are you exposed to an exchange really lawyering up or tooling up, so to speak, and incurring substantial costs to turn around and say, well, we don't, it's not ours, we don't have the information, or we're the wrong
Yeah.
people. Are you, because I know you've got that cross undertaking, is there anything where by way of court discretion or judicial discretion or anything that can help a claimant who might be exposed to a really overzealous exchange just incurring costs just to give them the answer to say we don't have anything?
The answer is very, very straightforward, which is write them a letter.
Yeah.
You write them a letter and say, can you help us? If they say no, then you're not on any cost liability. It's only when you go to court that you are, of course. But if you can say to a judge, look, we asked them to play nice 10 times and they haven't, then you can limit your cost liability. Similarly, and obviously there's a client in mind for you, Leon, which I appreciate is a position that we want to consider. I normally in letters say, we're treating you as an innocent third party who's mixed up in the wrongdoing. We will not include you as substantive defendant on the basis that you give an undertaking that you will not pursue our client for costs and you'll just provide the disclosure.
Yeah. Okay.
And they prefer that.
Yeah, that makes sense. I just wondered where you've got like a hot pursuit and, you know, time, I guess, is of the essence. I can imagine
the hot pursuit is important, but instead of rushing off to court and doing what they did in Perusa, it's much better to write them a letter and say, we're putting you on notice, you received the process of crime. Here are things you can and can't do. Because if they do that afterwards, that's as good as, in my books at least, getting them a formal order. The order is only there because they need an order to comply, but otherwise, you can do it much more cost effective and lower risk by writing letters.
Yeah. Okay. Cheers.
All right. Cool.
Hey, Matt. Hey, guys.
There you go.
I have a question. That was fantastic, by the way, and I'm sorry if I missed out on this bit, but if crypto is considered property under common law, has the tax man stepped in as yet to say how they're going to tax it? Are you going to get capital gains, etc.? What's the deal?
I'm not in a position at all to give any tax perspective, but I do know that Coinbase was sharing a lot of information with HMRC, which is our sort of tax wing of our government here in England. I think it's capital gains tax, Adela, which is what it is. It's frustrating, but it is what it is. But now there are pros and cons with it being property, right? Market confidence, people start investing in it. Downsides, got to pay tax. Sure,
yeah, but it does make it harder on the user side, right? So the owner, because now you have to start deciding, what the estate tax. So somebody dies, what does that mean? The income side of it, keeping track of a basis, etc. Well, I guess
you can only do your best. I'm not entirely sure there's too many accountants who are actually going to be in a position to help you. And imagine trying to send that to HMRC. Imagine sending thousands, well, here's my history. Here's 2,000 transactions on a blockchain. They're going to go. So I think you can only do your best. My friend recently, I think in the last couple of years, had a client whereby he made a ton of money buying Ether for many years. And I think he bought it and then lost his hard drive, found it again. And it was worth, 50, 60 million. And the first thing was, okay, great. You've got to pay tax on that. And this guy was like, I don't care. This is money that's come out of nowhere that I didn't have 20 minutes ago. I'll pay whatever tax I need to. Great, no problem. So it's annoying for mere mortals like us. But yeah, we have to pay tax. It's frustrating.
Right. So since the Guest Lab session has kind of transitioned by itself, why don't we start with introductions? And then, Matt, I'm going to ask you some of the questions that are in the chat. And we can spread them around the panel as well. So, Dels, why don't we start with you?
Oh my God, I hate doing it, but I'll do it. I'll take one for the team. Hi, everybody. My name's Adela Tullow-Foster, aka Dels. I started my journey in digital currencies in the early 2000s, so actually in the year 2000 exactly, by building a protocol to fractionalize the ownership of gold using a digital currency. So long time, being in the Bitcoin space, so before crypto was crypto, in the Bitcoin space since about 2010. And I've done everything you can imagine in that space, from, cleaning the toilets to just making sure people don't go to jail, asking for a lot of clarifications. I've worked with tons of private companies, have some of my own. And I have worked on the legislative side as well, with governments, with financial regulators, with investigative units, regionally and internationally. I have 2 law degrees that I could probably, I don't know, wipe the floor with at this point, because I just feel like I'm learning more as the day goes by. There's so many developments in this space. And more recently, I'm based between the beautiful island of St. Lucia and the shit show that is Washington, D.C. I'm very sorry about the language for everybody, but I'm pretty sure everybody's following America Season 2 keenly. And so that is it in a nutshell.
Thanks, Dels. Adila?
Hi, my name is Adela, and I am a crypto investigator and auditor. And basically, I serve on a couple of boards, helping to bridge the gap between traditional finance and also digital assets. Some of the work that I've been doing is going on speaking tours to speak with places like DC about their banking systems, and also here in Texas where I reside. Just been basically speaking with a lot of leadership organizations to help them understand digital assets in rapid changing environment of our financial system. And additionally, some work that I do outside of this work, I run my own company called DNA Legacy Blockchain Brokerage. And what DNA Legacy Blockchain Brokerage does is the tax implications, the bookkeeping for transactions and wallet management services. So that's what I do.
Thanks, Adila. Thanks for forgetting you are a board advisor, BLG, but it's all good.
Yes, I am the esteemed board advisor here at BLG and on the board for Women in Cryptocurrency, for Women in Cryptocurrency.
Yeah, thanks, Adila. Big up yourself. Yo, Ankh, what's up?
Hey everybody, it's great to meet you. Before I get slapped on the wrist too, I am a advisor as well for Blockchain Lex Groups. Beyond that though, my secular role is I am the senior manager at iHeartMedia. I oversee all things operational risk management related here. I am your GRC architect. I have about 14 plus years of experience in compliance, risk management, and governance. So I like to look at things from the blueprint perspective, from a risk management lens, and analyze things to really see what the potential risks are in the space of digital currency, all the way through blockchain, through Web3, and to really address some of those concerns that are risk related and from a regulatory perspective. Beyond that, I volunteer on some other boards as well and some other associations, but primarily I'm excited to be here and excited to see all you guys here as well.
Big up yourself. Keneal.
Good afternoon. Hope everybody's doing well. Pleasure to be here again. Keneal Legister. In my current role, I am attaché for the Department of Treasury IRS Criminal Investigation. But most importantly, I am Team Crypto Mondays Africa all day, every day. Blockchain Lex Group. Here to lend my expertise in compliance, money laundering, financial crimes, all that ties to blockchain technology and Web3. So pleasure to be here. That's a short ad-lib version of who we are and what I do. So pleasure to be here and ready to rock and roll.
Yeah, big up yourself, Keneal. Yo, Leon, walk on.
Hey, hello everybody. My name is Leon Hurd. I'm a senior regulatory lawyer at Keystone, and I specialize in emerging and disruptive tech in the emerging and disruptive tech sector, working with clients just to help them align their regulatory objectives with their commercial ones. a large part of my practice is working with those in DLT or blockchain, helping them sort of scope out their businesses from ideation through to development of MVP, right through to the scaling and growth sort of part of it, working with sort of their teams, their C-suite, to ensure that they are sort of hitting their regulatory objectives properly so that they can attract investment and basically not go to prison or be sued. So I have a lot of fun with what I do. I like to think I'm an unofficial member of the Blockchain Let's group. If it was Wu-Tang Clan, I'd be Redman. I'm just there to help.
Yeah, bro. Always got you, man. Representing in the ends, you know what I mean? Yo, Palesa.
Hi everyone, my name is Palesa. I am from Lesotho, Kingdom in the Sky. I've been working as a legal consultant for the past 3 years, I believe, and I'm an alumni of No Long Term Bootcamp and FemLex cohort, which actually influenced me to take my master's in the intersection of law and technology. Fast forward, now I am a director of communications and public relations at Blockchain Lex Group. But on the side, I am a founder of Digilex Solutions, which basically raises awareness around cyber safety in Lesotho. We also try to educate Basotho people about the crypto basics, blockchain basics, and the threats surrounding them, actually, the emerging technologies. What we're trying to do basically is just to bridge the digital divide in Lesotho and try to give people this basic information or basic education around the emerging technologies. Thank you.
Thanks, Palesa. And everybody, I'm Brian Mondo. I'm really grateful to have all of you. So let's begin the lab with this question. Where is the consumer amidst all this? What's consumer protection like from the common law position? And I know this captures the Caribbean islands that are of British descent and Lesotho as well as a common law country. And I know the positioning of the legal direction in the US is sort of different, but what does all these overlaps mean for the consumer? Anybody can pick it up.
I can start it off. I can speak just for the US region because it is a little bit of a wild, wild west over here. As she mentioned, we are in episode 2 over here, so things are a little bit crazy. So when we're talking about consumer, typically, whenever there's a consumer complaint or anything that needs to be addressed, we typically would reach out to our CFPB, which is one of our regulatory agencies. However, a lot of changes has occurred within that particular regulatory agency as far as leadership, as far as what their focus is, and as far as what you can bring their concerns to. So if I were to, I guess in a nutshell, provide next steps as far as the current climate and environment of things, you have to really take a lot of ownership on your own self. You got to be really proactive on identifying your concerns, making sure that you're calling out the appropriate risk, doing your own research. I mean, you have to basically be an entire company within yourself right now, right? If you really want to make sure that one, that you're still adhering to certain laws and regulations, you have to be acclimated with yourself. Also, you have to identify, does this truly qualify or count as a complaint, or maybe, let's say, a risk that you've identified. So there takes a lot of proactiveness on your behalf that you have to take currently right now until things kind of make sense here in the US, because right now they don't make sense. So that will be my response to that question, I guess.
Thanks, Devon. Anybody else want to chime in on that?
If I may,
Yeah.
I do
Yeah.
have to say, it looks like this current regime might be very friendly to crypto. But what happens from here on out is, look, I like to see the proof first. I like the receipts, and then I decide, how I feel about it basically. But, I think it's important for people to understand that there is a regulatory turf war in the US. So as a business, what that means is that you not only have to contend with federal laws, you have to contend with state laws as well. So for example, if you are an exchange, you have to register with the US Treasury and you have to abide by every single stipulation by the Bank Secrecy Act. And you still have to pursue licenses for every state that you do business with. And there's also the IRS to worry about. They also treat crypto as property. So there is capital gains taxes. So you want to get right with the tax man first. I always tell people that's how Al Capone went down, not for murdering a bunch of people, but for not paying his taxes. So there is that. There's still a bit of uncertainty. So, what the future holds is yet to be seen. Down in the Caribbean, we're seeing a progressive push towards adopting friendly regulation that is that I believe will open the door to more to crypto companies, because we are really trying to provide that clarity down here. But it is a bit of a struggle. It's untread waters, and I think people are a bit fed up of the reliance that we've used. So we're seeing the advent of sandboxing with the regulatory authorities, and the financial services regulator in St. Lucia just announced that they're going to be launching a sandbox, which is extremely exciting. So these are cool and exciting times, a little bit depressing sometimes, but it's not all doom and gloom.
And Dels, you and Keneal, which Caribbean islands are you seeing most movement? Because in places like Trinidad, come on, we're still not there.
Yeah, well, I can tell you for St. Lucia, the regulators they're keen, they're there, they're willing, they're ready to go. They adopted legislation in 2022, and now about to launch this sandbox that I've told you about. So they're ready and open to receive applications. They're willing to work with the applicants. The Caymans, of course, they're ahead of their game. Bahamas, very friendly. Bermuda, also very friendly. So it's definitely, again, a sort of case by case, the islands, a lot of people don't know this, but there are different cultures on the different islands.
Right, cool. Adila, you want to chime in on that?
Absolutely. I would say that we've enabled a landscape of distrust amongst consumers, not for digital assets, but for traditional banking systems. There's over thousands of banks that's closed within the past 3 months in the United States alone. And I feel that they don't, the consumer, if we're speaking just about the consumer's lens, I would say they traditionally don't really trust the banking system, but they don't have a choice, because that's the type of system right now that dominates United States. However, given the aspect of the current administration's thought process in accepting the digital assets, we just don't know yet where that's going to leave the consumer. But we know that they are open and privy to a digital asset environment. With that being said, I feel that it's going to allow more consumers to adapt digital assets a lot faster and sooner now, more so than ever, because there's traditional banks closing. If they're losing hope in the traditional banking system and they see that they can leverage the digital assets, then I feel that there is hope there. And for that matter, we're already utilizing digital type of I would say digital type of transfers. We're already getting kind of accustomed to that, where you're utilizing a Zelle or, a Cash App or a Venmo. They kind of understand how it works, but they're not yet sure of directly putting their money into crypto. But I think that that's going to change soon.
Right. And do you think we're also going to see more rapid movement in, let's say, Africa and the Caribbean?
Absolutely.
Yeah.
Jack Dorsey, even though he just laid off some people there at Block.com, I feel that he's paving the opportunity to open more business in Africa. So a big company like Block.com going into Africa means that there is more hope for that landscape to be able to be the poster child, if you will, for what a environment looks like that is doing cross-border trading and trades in digital assets, because I really feel that's where the direction is going there.
Right, thank you. So let's there's a question here that says, how would the outcome of Bybit differ if it happened in the UK? Martin Leon. So let's say Bybit, FTX, and all the other scams, would it differ if it happened in the UK?
My view of it would have been yeah, because it was pursued largely, I think, by law enforcement out in that jurisdiction. Here, it would have obviously been law enforcement as well, but private individuals could have assisted in going to court in the way that I described in that process. I just don't think that process described in that presentation is necessarily available via other jurisdictions and various courts. So what it could have done is immediately try to freeze funds at certain exchanges. Even now, they could be doing it and getting those proprietary injunctions, which would allow funds, even though it's gone through exchanges and out the other end, to still apply. So it may well be that actually there was something to be done, which is, I suppose, it also falls into the realm of what powers are given under the Proceeds of Crime Act, and how law enforcement can use civil rules as well as criminal regimes to help. I just think we've got a broad swathe of tools in our chest, and I'm not entirely sure that other jurisdictions have those.
All right, thanks, Leon.
I'm minded to agree with Matt. I actually think in the UK, and it goes back to something that was in Matt's presentation, the whole judicial canon approach that I think we have at the moment. Basically, you've got judges being given license to kind of be quite creative with the way that they're sort of applying things. It would have probably plays out slightly differently here than it does in a more codified jurisdiction. But I think it's interesting the way that things are developing, and yeah, I think where I think the thought process needs to be now is a little bit more around, what are around regulators and law enforcement working more closely together to try and do things on a more sort of a collaborative basis, because I think that's something that has been missing.
Right, thanks, Leon. So Devon and Keneal, in terms of Bybit and FTX, what do you think could have been done better? And in upcoming jurisdictions, let's say in developing countries like Africa, but later on, would you tell us, like, if you had a FTX sort of situation in your country, what would your institutions there, how would they deal with it? So let's start off with Devon and Keneal. Devon, your mic.
I'm sorry, repeat that question again, Brian.
So as soon as Bybit happened, you made some commentary about it. And this isn't far back from FTX, okay? So how would it be handled better, and what repercussions does it have moving forward?
Well, I mean, there's a couple of factors here. From a GRC perspective and like a cybersecurity perspective, working in this environment, whenever there's an incident that has been identified of that large scale, where we see there's critical assets on the table that are billions, it needs to be handled very delicately, right? And that's where, in the space of, I would say, blockchain and just the new environment in which we are handling incidents like this you have to straddle the line, right? Because once you want to allow the community to see that, hey, I am being very transparent, this is the issue that has occurred, but at the same time, there has to be a level of privacy for the sake of your organization. If critical error has occurred, or let's say an incident has been identified of this nature, private is best until you can figure out and do your proper investigation on the back end as far as how did this occur, who all is impacted, and just get a true understanding of, is this the total assets that's been impacted, or are we just providing detail to the media as we get them? So to really keep that integrity intact, you really have to walk that fine line between allowing your organization to see that you can be trusted but also having a level of privacy to understand that, hey, I'm handling these assets with care. Because again, going back to that consumer that we talked about earlier, you want your consumers to understand that they have trust and that you're handling their assets with the utmost care. So
Thanks, Devin.
Definitely 100% agree with Devin. And then from a totally US perspective, I think one thing we have been able to do is leverage a lot of our partners, a lot of the crypto analysts out there, or the analytical software companies out there. Don't need to name all of them, but you know them. The reality is that we work hand in hand with them, and essentially I love the community policing, because one thing I noticed is that everybody started to chime in that had access to these tools about where the funds are going. So from the US perspective, we do have a huge network of tools and people that are able to identify fraud, freeze things in place, and try to make, if they can, make certain people or entities whole. So I do appreciate the fact that, name it, all these companies down to the law enforcement agencies, as soon as we all get wind of it, we launch. We have obviously CISA. Don't ask me for an acronym. Please Google that. The Cybersecurity Incident Response Team. So essentially, there's a purview and a prospect now to essentially identify fraud and start mitigating any type of outstanding risks that we have.
All right, thanks, Keneal.
If I can also just back up what Keneal is saying too, because there is actually some important factors as far as like lesson learned, right? That we're hoping that the organization that was involved with this crypto heist really tries to improve going forward. One of that is incident response and business continuity. I really hope that they really take this as a lesson learned and really create some structured framework around how they handle incidents and what does that response look like. And also from a business continuity perspective, do we have one? Because believe it or not, some of these startups sometimes don't even have a business continuity plan in place that allows them to proactively hit the ground running when an emergency like this occurs. So that would be just my 2 cents to really, as a lesson learned to the larger audience, whether you're in your own field starting a startup, create that incident response, have a business continuity plan, because that will save you a lot of headache in the future. So,
okay. Well, let's one real quick. Yeah. So, sorry, Leon. Okay, Leon.
Just from the UK's perspective, I think what an incident like what Bybit does is it focuses the mind, or I certainly think it focuses the regulators' kind of desire for more centralization in what we want to be a decentralized world. It kind of, they want to have large institutions that they can hold to account. What will have kind of developed and complex incident response systems like you just talked about, Devin. I think that's a more comfortable place for the regulator, and they'll leverage off these sorts of incidents to say, it's too unsafe to have a disparate bunch of providers, and we want more, we want consolidation, and we want to have close scrutiny and supervision of those fewer operators in the space. And so we might see that type of sort of effect within the UK at least.
Yeah, and Leon, for instance, with the FCA, for example, today I was watching a video on LinkedIn where the FCA said, and that is why we just say, don't touch it. If you invest it, you're going to lose it.
Yeah.
So if the regulator is telling you that, it doesn't sort of progress this industry, because it's like, you touch it, we're not going to deal with it. I prefer the American approach whereby they're trying to deal with it. It's not the best way they're handling these things. And right now, everything has been, reset, but they tried. In the UK, they haven't tried.
That's all. No,
Yeah.
It's a real inflection point, Brian, I think. It's what do we do? Do we take this opportunity to kind of see DLT blockchain as a new opportunity to do things differently, or do we sort of say, no, we want to shoehorn it into the old TradFi systems and want to basically transpose all of that on top of blockchain? And I think nobody really knows. We're not sure if MiCA is going to work. We're not sure what the US is doing necessarily, or kind of if deregulation, if you want to call it that, is going to work. And the UK is probably trying to work out what's the happy halfway house between both extremes. But it is a real interesting time, I think, in the world for crypto, quite frankly.
Totally agree. Del,
It's a weird flex, right? Because on one hand, you have the US that's like, move fast, break things, you know, and then you have the UK that's like, well, let's measure this 7,000 times, but we're not sure we're going to cut it. You know, like there must be like a nice middle ground in there somewhere. And I think to Matt's point, I really like the common law for that, you know. I think that's where the judges kind of need to step up on their knowledge there, right?
Yeah.
And start giving us some clarity, because that's the whole point of common law. Sometimes if you can
Yeah.
get very locked into legislation, and I always say legislation never opens back up. It always just narrows back, you know, down. So
Yeah. You know, just as a comment on that, Matt, I think 2 weeks ago we were at the House of Lords, right? And we assumed being in the House of Lords, you're going to be having progressive discussions. But even there, people still don't know what's going on. And then
People were annoyed, weren't they? People were
Yeah.
annoyed.
literally nobody knew what they were saying. And then speaking to Adila and Kinil and Devon in the US, they're like, no, that's not happening. And I'm like, isn't the US the most like one of the leading developed countries? So people in developing countries think that the developed countries have it on lock, but literally there's nothing going on.
I think there's lots going on. It's just it seems to have been fragmented, and people are getting frustrated that there isn't one aligned policy or movement. You know, we haven't just had, but I suppose in the grand scheme of things, we just had a change of government, and there was an all-parliamentary group on digital assets, and that's been dissolved. And has anybody picked up the mantle? No idea.
Yeah.
With
I'm
that,
so
that's
glad
sort
you
of the
flagged
problem.
that, Matt. I'm
Say
so
again?
glad you said that, because it scares me that there was such chat and momentum for sort of bringing it, for being the crypto-friendly jurisdiction, sort of what in sort of June and May and anyway, everything before the general election, and
Yeah.
it's sort of just completely silent now, which is quite terrifying, really.
Yeah.
So,
it is, yeah.
guys, hold up. Adila, I know you want to say something, but let's quickly hear from Palesa. What's happening in Africa, Palesa, especially within the Southern African region? Because we know South Africa as a republic is supposed to be at the forefront of these things. Nigeria as well, Kenya, and you in Lesotho, which is literally a country within a country. Well, what's happening in there?
Oh well, for South Africa, I'm aware that it has actually started regulating cryptocurrency, but in Lesotho, there's no regulations. In fact, the Central Bank of Lesotho did say it does not regulate it. That was in 2018, if I'm not mistaken. 2018, I think. So the other thing is that even the VASPs are not licensed in Lesotho. So
So what happens when
there's
people
actually
want to
nothing.
interact with these assets within your region?
Yeah, no. Lesotho does, like Lesotho people do interact with crypto assets. They do trade, they do buy crypto assets. But the problem is, even if they lose them, they have no protection whatsoever. And
So just to follow,
it's actually not recognized as property, like Matt Queen has said that it's in the UK. But here it's not recognized as anything, actually.
so what
So if you
about in the courts?
yeah.
Yeah.
in the courts, the problem is, how can we go to court with something which is not even recognized or regulated in Lesotho? Like, we don't recognize it. When you talk about cryptocurrency in Lesotho, people are still at this point where they think it's just a scam.
Come on, let's
We're still
unpack
there.
this. What
Mm.
laws do you use as persuasive or binding?
We have common law, of course.
Yeah.
We have common law, yes. Yeah, we do have common law. We do get persuaded by the common law, yeah. But the thing is, at this moment, we've never had anybody who brings a case to the court and say that I've just lost my digital assets, I just lost my cryptocurrency, so can the court intervene? Nobody has ever said that, because if the central bank says we do not recognize cryptocurrency, if you engage with cryptocurrency, it's
That's
all
it.
on you. If you lose
Pay
it,
a
it's all on you.
Yeah.
How is that under their mandate? Like, I don't understand. Like, central banks should have absolutely nothing to do with the regulation of cryptocurrencies whatsoever.
Yo, but Dels, quick observation in the Caribbean aspect. only the BVI has like progressive, like legal precedent, and they read from the UK. I was in Jamaica and talking about this regime, and they're like, there's no such cases in the courts. So I'm not surprised when there's no such cases in Lesotho, because only the BVI literally has a case, chain swap, the chain swap case from the BVI. That's the only case I know. Leon, have you heard of any other?
The Bahamas has the
Bahamas
FTX
has a
thing
case?
that started.
Yes,
Yeah,
I'm
that
about to
got
say.
started there. Yeah.
Yeah,
Hi,
yeah,
Keneal.
yeah.
Here's the thing. Here's the thing. We do have like a Commonwealth model law on virtual assets. There's like this legal framework that is made for Commonwealth countries, but Lesotho has never done anything to it or tried to engage with it or try to do anything related to cryptocurrency, although there's actually this legal framework in place.
Question,
Yeah.
question actually for Lisa. And just to let's take a step back actually, because I always try to differentiate laws, policies, and rules, and then there's practicality and reality, the way I call it, right? So question, what happens when a citizen tries to go to their bank and wire money to an exchange? What happens? Palesa.
At first, there was just more like people were just made aware. If you get involved or you buy cryptocurrency, know that if you lose your asset or you lose your money because you've invested in a cryptocurrency, we're not going to say anything. We're not going to help you if you lose your money. But it
Fair
does
enough.
not in any way stop you to buy cryptocurrency. You
Gotcha.
understand?
So
So
you
you can
The
still
reason
buy
I
banks
asked that,
allow
cryptocurrency.
you to do it.
so you are allowed to
Sorry?
do it.
Yeah, the banks
Yeah,
they
you
allow
can.
you to do it.
I buy
So,
cryptocurrency with my bank card like all the time.
Yeah, but
so
man, in the UK, banks like Santander don't. At
they don't
times,
allow.
there are times they are shutting down consumers. They are not allowing
Correct.
those transactions, right? Leon.
Yes, what they do is they'll say,
Yeah.
in certain instances, when say your Coinbase account links to your bank account, they used to block it. The bank
Yeah.
used to block it. Or now what they do is they say, well, are you sure you know what you're doing? Push this button to confirm that you're making a crypto transaction, and you're doing this at your own risk. But it's not the bank's decision. It's my decision as a consumer to do whatever the hell I want with my money.
Interesting. So that's the reason I brought that up. So it's one thing for us to sit here and say a lot of these countries' policies and regulations don't allow for you to be progressive and interact with these exchange or cryptocurrency or any type of blockchain network. The fact that your bank doesn't block you gives you the option, which is power, because I get it. We're really trying to force centralized rules into a decentralized system. That whole square peg into a round system. But nonetheless, I say that you do have jurisdictions that ultimately block you, and that's their stance. To your point, Adela, about the central banks making these policies, there's some outright in these jurisdictions, Trinidad, for example. For a while, they weren't blocking you. Now it's considered illegal for you to enter. Same thing here in Barbados. They have ATMs, but at one point they said, hey, dude, this is a scam. You're blocked. But then people, just as you're saying, there's individuals who are saying, hey, this is my money. This is my choice. Whereas some jurisdictions don't even have that option. So
Yeah.
I get it.
See, here's something that grinds my gears with this in its totality is the fact that, this is just from a risk management perspective, but why is it that when it has to be a case that's presented or incident that occurs, we need to really get away from the reactive environment and be very proactive. That's the only way things are going to be sustainable if you want it to truly exist in an ecosystem. You can't just always be reactive when something happens or when something occurs. If you're seeing it in other demographics occurring, if you're seeing, let's say, a fraud issue with like a crypto transaction happening over here, well, take heed to that. Apply that to a policy early on. Use that as an emerging risk before it becomes an existing risk. And that's how you stay ahead of the game, because you can't live in a reactive mentality if you really want this to truly be a part of the ecosystem like we're trying to make it.
I mean, I would even proffer that no compliance is non-compliance. And de-risking an entire category and group of people is not compliance. That's borderline discrimination. Actually, that is discrimination. Let's take away the mincy words. It is discriminatory. And I've had it happen to me. And I know people who say, it's happened to. But now we're taking a bit of a stronger stance down here. Keneal?
we were doing some work for a client, and the client needed a bank account in St. Lucia, and source of income was crypto. They said, nah, we ain't dealing with that. We ain't dealing with that. Go. So I'm really surprised that you're saying St. Lucia is kind of forward thinking when it comes to this. It's really taking
They're getting there, but you've got to make a strong case. Like you can't just go like crypto. It's not a, you have to really give it, because remember, their policies are a so-called risk-based approach, right?
Yeah.
So you have to assure them that they're not taking on some wild risk and about to lose their correspondent relationships, blah blah blah, because that's the biggest concern down here, is that people are not going to be able to receive money from overseas or send money to their kids at university.
Yeah, thanks, Del. So Matt has to jump into another meeting. Matt, do you just want to give us your last takeaway, and then I'm gonna go through the questions in the chat before we wrap it up?
Yeah, sure. The takeaway is thanks for having me, Brian, really. And I presented on something that was pretty law heavy, but bear in mind that that's just this jurisdiction, and other jurisdictions have their own rules and trajectories. Hopefully for those in different parts of the world, that presentation at least gave some guidance as to how we're doing it over here, and hopefully inspired some people to get stuck in to this sector. But overall, just, thanks to everybody who's made a contribution on this call. Hugely appreciated. And find me on LinkedIn if you want to follow up with some questions.
Yeah, cool. Thanks, Matt.
Pleasure, guys.
Very much. All right, cool. So let's take this question from Paul Makolaka in Kenya. Yo, Paul, big up yourself, man. So when tokens go through privacy preserving platforms like Zcash or Monero, how hard does it become, and how does that change the strategy in terms of the path taken? So Adela, I know you're into this technical aspect of things. What does the obfuscation process do in terms of asset recovery? Does it make things more difficult?
I'll come back to that one. I gotta take a quick call. I'll be right back
All right, cool. Anybody else?
after these messages.
All right, cool. Dels, Kinil, Devon, Leon.
Repeat that one
mean-
more time. Sorry, I'm trying to get off of mute here. Sorry.
So, right. So basically, when coins go through a mixer or a tumbler, what happened? Does it make it terribly hard for them to be traced? And in terms of strategy moving forward, what can someone do in terms of finding those assets?
From an investigative lens,
Yeah.
you do have programs in place now, Trim Labs and Chainalysis, where you can find out the origin of those coins if it goes through the mixer. I mean, I would say that mixers, their job is to kind of take all the coins and then mix them up and, give a different type of address. But there's ways to find out the origination of it before it was mixed. Now, the whole premises, though, of being able to trace assets, well, that's the purpose of the mixer. They don't want you to be able to trace the assets. But again, there's technologies that will be able to help. There's some that goes through the, that can go through that. But then for the most part, there's ways to kind of unlock, what happened.
But Adila, in terms of the mixing services, people assume when you use a mixer, it's a bad thing.
Not always. Not always.
Depends. I
In
think the
general, they
answer
do.
is-
In general, yeah.
Yeah.
In
Kinil?
general. No, I agree. In general, the perception is that you're doing something bad, but I think the way these companies set up themselves is to essentially provide you the ultimate privacy. And but you're right. To answer your question, yes, it is only designed to obfuscate. I don't think especially from an investigator standpoint, it is harder. You do assume the worst when these are being used, but these are tools that are ultimately out there for you to utilize to your benefit, where essentially you don't want anybody to know what you're doing. You want to keep your transaction anonymous. And for privacy, it's almost, and I always attribute this to like VPN. You do want privacy and protections, right? I try to use this as an analogy, but just to keep this short right now, it's what's wrong with trying to have some sort of privacy and protect your information as well. I
Absolutely.
think that's what.
Allow me to mute this first.
Yeah.
Hold up, Devin. All right,
I
Devin.
got it.
Unmute it. Devin, your mic is on mute.
Oh, I'm sorry. Were you done, Kenil? I didn't want to interrupt you.
No, I was essentially that
Okay.
was the gist of it. Yeah, risk
Yeah.
and obfuscation. Yeah.
Yeah, just to echo Kenil's point, because I mean, case in point, what occurred with Bybit. I mean, we saw that that's how those stolen funds were quickly laundered through crypto mixers and cross-chain swaps. But what's key is this. Okay, right now we look at the current environment. A lot of things are not regulated. In a typical regulated environment, let's say the traditional world I work in, um, there are potentials of several different audits that can occur. And when audit occurs, what do you have to have? You have to have that document trail. You have to have that evidence that say, hey, this is what I did. This is how I recover those funds, things of that nature. Now, we might not necessarily be there yet, but it's important for a lot of organizations right now to start enhancing their AML and forensic tracking on chain analytics, because you're going to really at some point need to have proof that, hey, I did my due diligence. That way it covers yourself in a regulated environment. Now, right now, you're fine. But once things get regulated, that's a different story.
And just going back, with Devin's point, going back to that audit trail, just considering, if you are trying to put funds in a Cayman or you're trying to do business with a big bank, then I'm sure that it would be appreciated if you can show proof of funds. And then if you did put some of those funds through a mixer to help the privacy of your clients, maybe it's a big client that don't want, or a whale that doesn't want everyone to know, then perhaps there's ways to be able to traceability, back to that audit trail.
For sure.
That will be important.
For
Yeah.
sure. For example, if it's a CoinJoin or a mixer and the mixer actually keeps a log, then there is that. That can be de-anonymized for sure. So it's possible, it's hard, but I would just assume that everything on chain is going to be visible at some point. And especially think about it, people off ramp, like you have to off ramp at a certain point,
Exactly.
right?
Yeah.
And that's like a major vulnerability. And also, I just want to say, like, obscuring your path on the internet is not illegal per se. It can be illegal, but it is not always illegal. So using a mixer or a CoinJoin is, let me not say it's
Choice.
not illegal.
Choice.
It should remain a choice. When I go to the store, I don't want to show everybody the contents of my bag. That should just be mine, between me and the nice lady or the self-checkout, technology. I think it's completely okay. I mean, when it's used for bad purposes, that's when we want to find the bad people. And I actually did assist with a very big investigation involving a very bad country, which is bad for all countries for now. And
Why are you sounding like Trump? Some really bad
Touche.
people.
Listen,
Touche.
Like some
taking the
really bad
temperature.
people. And some really good people. Like,
It's
yo,
rubbing off
what's
on
going
everybody.
And we were able to extrapolate a lot of information and use probability to pick up a lot of data and link a lot of the addresses that were sent through mixers and CoinJoins. So, like I said, big vulnerability if your mixer has a log. It's over. And then the ISPs usually, when they're cases that involve such horrific things of horrific nature, are happy to give you information, and of course off ramped. So hard, but not impossible.
Thanks, Dels. So let's take this last question from the chat. So, can private firms in countries that are yet to recognize cryptocurrency as legal tender use centralized exchanges in their trade without having problems with the federal government agencies? So, if the country doesn't recognize it, could they still utilize the centralized exchanges?
Well, I mean, I can say this. Let's take China, for example. They're a big they're a Bitcoin holder, but they want their people to utilize their own internal coins if they're going to utilize. So I guess it depends on the objective of the country, number one. You know, if the objective of the country is to collect coins and hold them and build a reserve off of them and not allow their countrymen to utilize these coins, that could be one way of looking at that. But then the other way would be like what Pelissa was saying, you're allowed to buy it, but we're not going to be responsible. So I guess it depends on your country.
Yeah. And then is it possible for like, let's say, exchanges like Binance or Coinbase to really operate in a country if they don't have a license in their country? I highly doubt it, because if Binance in some countries doesn't have presence, if you go to their website, they tell you we're not supported in this region.
Yep.
I don't
But
think they have
use
like
a
one
VPN.
physical office anywhere, Brian. Do they? Has anybody been to the Binance the
I
Binance
think they
building?
have
I know they're in
they have an
UAE.
office in Dubai.
Do they
Yeah.
have one there?
Is it?
Yeah, they
Okay.
have proper presence in Dubai.
I'm
But
not sure they have an office
That's where a
anywhere
lot of the
else.
whales hide.
yeah, but
That's
their
where a lot of them
websites,
hide.
yeah, but their websites are gonna tell you. Like I think in the UK, you can't access the Binance website. I'm not sure. Leon, can you access Binance in the UK?
You couldn't the last time I checked. I haven't
Yeah.
checked it recently, but they basically got locked out because they wouldn't. I don't think they met the requirements to be registered as a VASP exchange. I don't know if they had adequate enough AML processes. I'm not sure where they're at now. I know there's an ongoing dialogue.
Mm.
It's
Right.
quite
Question
public knowledge, but I don't know where it's landed yet.
Question with that exactly. Now, just clarify. So if you're in the UK right now and you open your phone and go on a VPN, you cannot access it.
No, you will be able to, the VPN.
With a
I just
VPN
want
on
to-
Tor? What about Tor?
I just want to clarify that part. That's all.
I think that
Just-
I think that is pretty much what the entire industry.
I just want to put it out there.
No, someone has started sharing. Oh, okay, it's Adila.
I just want to say
Yeah.
something about Binance and Lesotho. You see, I can buy cryptocurrency on Binance, but the problem now is when I want to take it back to my bank account.
To or from it. Yeah, that's what Dell said.
As you can see, this is Binance in the United States. So correct your servers. If you're in a country where it's not accepted any type of exchange,
Yeah,
it's going to block it. As you can see here, it says
yeah,
Binance is unavailable in your country region.
yeah.
If you're United States and selected territories.
I mean,
Yeah.
the way the UK works, it's quite draconian
Yeah.
because we have the financial promotions order, which prevents you from even marketing
Yeah.
qualifying crypto assets, of which all crypto assets on an exchange are likely to meet the definition, i.e., are they fungible and are they traded? Are they tradable and fungible? They're qualifying crypto assets, and you can't market them unless you've gone through one of the gateways. So that's why there's so it's really difficult. That's why you ultimately you'll see people use VPNs, and because there should be geo-blocks at source, really.
Alright, cool. Yo, so I'm gonna give the audience one question, and then we do takeaways and we call it a wrap. So there's nothing in the chat. So anybody in the audience who's ready to jump on the mic and ask a last question or to give their takeaway, we'll allow you this chance to. Otherwise, we're gonna proceed and do our takeaway. 3 seconds. 2, 1. Okay, it's gone.
I'll just say, oh,
Wait, that's in the audience?
yes.
Yeah, go ahead.
All right, yeah, cool. Tell us who you are, where you're coming from, yo.
My name is Sade. I'm in the US in Florida.
Right.
Just want to say this is really awesome. I'm just really enjoying this. But my random takeaway is that it seems like the UK is way stricter than the US. So I'm kind of surprised. And I'm surprised that there are some countries that are, completely blocking even like using, highly regulated exchanges like Coinbase. So that was just helpful to learn. I didn't have any specific question, but that was just
Is
a takeaway
Coinbase
I had.
regulated, really, guys? I thought Coinbase
Well,
you'd rather
well, they participate with law enforcement, they participate with rules and regulations, and they report suspicious transactions. So they more than most exchanges follow a lot of the compliance and regulatory rules that typical financial institutions have to follow.
They
at
are
least in the
highly
US.
regulated. They are. They're registered with the Treasury. They have licenses for every state that they operate in. They are highly regulated. They do SARs, CTRs, the whole 9 yards.
All right, cool. Cheers. So let's do our takeaways. Lawal, send me an email to admin@blockchainlex.io, and then we'll find some some regional experts rather within your locale. And Palesa and Gabri always doing things with Crypto Mondays Africa. So we're going to have people who are more relevant to your locale, okay? But we try as much as we can, and our experts, international experts as well. So they have this sort of satellite knowledge when it comes to matters. But I've taken your point, but just shoot me an inbox and then we'll pick it up from there. Okay. So Dels, you wanna start off with the takeaways, please?
Oh, I just want to thank you for having me here, and to everybody who's in the audience. Hey guys, thank you so much for tuning in and coming to hang out with us. I know Matt isn't here, but I mean, wow, what a great way to get a pulse on what's going on. And of course, you, Brian, thank you so very much. And my other very brilliant co-hosts, you guys are amazing. And I've never come here and not learned something from the panel or the audience. So thank you for that.
Thank you very much. Adila? Adila, your mic is on mute.
I'd just like to say, it's always nice to look at the different perspectives globally to see what's capturing us in this space as far as it growing. We see that there are places where growth is halted, but at the same time, we can use that collective energy and that collective idealism to be able to penetrate through more barriers. So I'm just very grateful and thankful that we're here and we're able to have these discussions at length, and also be able to tell the students what to expect when they do get out here in the world and they do want to practice actively utilizing digital assets. This really helps as a precursor, and it helps them to be able to leverage. You're not going to find this information in the textbook. This is like on-the-go education, and you have to be agile to be able to consider what's occurring in the world. So I'm just grateful for the opportunity to be.
Grateful, Adila. Palesa?
Oh, thank you. I just want to say I'm grateful to be here, and I've learned so much from everyone. And I just hope one day I'll be having this discussion with you guys, telling you how my country is now regulating crypto assets and we're benefiting from its economic opportunities, Hopefully me being here, because this is like a platform. It's on YouTube, of course. It's live on YouTube. So hopefully somebody will see it and we can have a better discussion about how we can get involved too in these opportunities. Thank you.
Thanks, Palesa. Palesa, and if you could just add something like somewhat of an encouragement to the students, because you've been there where they are now, like what would you say to them? Palesa, your internet has dropped. Power outage.
Stay tuned next episode for those encouraging words.
And they should know that.
Palesa, what happened? You hanged.
You froze. What happened?
Okay,
No pressure,
take it
no
back,
pressure.
take it
Yeah,
back.
no
Rewind
pressure.
select.
Yeah, I just
No pressure.
my manager just got unstable there. Okay, I was just saying. I'm saying that I think I should just let our student know that I know some of them probably have missed some of the sessions. They should go back to the YouTube and try to, to catch up with everybody else. But this is such an awesome learning opportunity for everyone, despite where they are. This is just one of those educational initiatives that can be reached by everybody without it doesn't matter if you're from the developing or developed country. So it's more like it's giving opportunities that we should participate equally, So I would encourage them to keep on attending classes, do their assessments so that they can earn their certificates. Yeah, that's what I'm gonna say.
Thanks, Palesa. You know, Palesa, you're the chief whip of BLG, so mad respect. Yo, Leon, welcome, bro.
Yes, Brian, how you doing, man? And look, thank you so much as always for having me. It's always a pleasure. And just to echo what everybody said, you know, it's a great learning experience, it's a real opportunity to have a debate and discuss things that are really at the forefront. I think in terms of my final words, I don't know, I just think we're all very privileged to be in a space which we're seeing develop and grow in real time. We always end up looking at things historically, but I think we're all very fortunate to see the development of this space as it's unfolding, and we're seeing it with the thanks of technology and where we are as a society. We're seeing it internationally. I love hearing about the developments in the US versus mainland Europe versus parts of Africa. It's wonderful. And I think for all the founders out there, for all the builders out there, for everybody wanting to utilize the technology, don't be overwhelmed, do your homework. And where there is uncertainty, there's opportunity. And I think there's a lot of opportunity for everybody as this space grows.
Yo, bless. Keneal.
I'm gonna start suggesting we need a blowhorn. There's these epic moments, and all we could do is smile and do little finger claps in silence. But I appreciate y'all. Actually, my first two takeaway, one is actually a question, and I already asked it, but I wanted to resound with everyone. Are we really trying to apply rules of a centralized system to a decentralized system? Let's really start thinking about that as we go forward. But with that said, I'm gonna be me, right? I gotta stay true to the grain. I still believe that the only way forward is for our ecosystem is to develop rules and regulations so we could draw that hard line or create, quote unquote, a fork in the road so we know to go left or pivot to the right. Everybody have a good one.
Yo, bro, where do you get this deep shit, man? You and Devon, where the hell do you get this deep shit from?
Yo, the man them have chat.
The man, them are writing lines. They're always writing lines, man. Yo, hold
Stay
on.
ready.
Drop the favorite line. Each one teach one.
You got to write this one.
Each
Once
one
we all
teach
start to
one,
learn,
yeah.
each one. No, you got it right. Each one teach one. That's what this is about. This is
Yeah.
our community. So
So
bless.
Leighton, you
We'll
posted
get
about
there.
an assignment. Yo, the assignment is to drop your knowledge on social media, like tag people, like a few items you've learned from the bootcamp from last week, this week, yeah? Just share the knowledge with the world. That's it.
Mm.
Devon, now you have the biggest deep book.
Oh,
Drop the
goodness,
lines,
man. Don't put that pressure
You
on me,
drop
bro.
that thing, man.
Don't do
Devon,
that.
just drop that thing, man.
Oh, man. Well, so first and foremost, another amazing session. I joined a little bit late, so I'm not sure if this was covered, but I wanted to really talk about it. Just the opportunities that we see here. You know, we are witnessing the elevation of compliance, not just the evolution of it. And when we think about in the world of Web3, cryptocurrency, AI, decentralized ecosystems, compliance is no longer the department of no, it's really the team of how, as in how do we innovate responsibly, strategically, and sustainably? Well, what I'm seeing as far as a lot of compliance roles that are really booming and are explosive right now, I'm seeing Web3 compliance strategists, crypto risk analysts, AI governance officers, even DeFi policy leads, and blockchain forensic control specialists. So, you know, these are real jobs that are now becoming a part, again, it's a buzzword, but a part of our ecosystem, right? These are hot jobs that fuse emerging tech with enterprise level oversight. And here's the part that I love working as a GRC professional. Your skills aren't just transferable, they're foundational. If you've built controlled environments, assess risks, whether that be navigating audits or even develop compliance framework in traditional environments like finance or healthcare, or even media like I'm working in, you're already ahead. The only thing that needs to change is the infrastructure and the speed. So apply what you already know, but realize that you still are a valuable asset in this next emerging ecosystem that we are building today. So just remember that it's not about the compliance department of no, we're the team of how. How can we make it happen? And we will, because as I sit here and look at all of these students today, I know that we are in good hands.
Yo, I told y'all, Keneal and Devon, they have those deep encyclopedias and shit, man. I don't know, man. So anyway, from me, mad love. And I'm just gonna tell you one thing. A closed mouth don't get fed. You might be taking this thing for granted because first of all, it's free or whatever. But don't, man. You will never get this sort of quality of knowledge, quality of experts in one room at the same time in the sequence which they're appearing. It's like Tom Cruise, Sylvester Stallone, whoever, same screening, same time. It's like the Expendables a million times. If you haven't watched it, go watch it. Like it's so star-studded, you're never gonna get that kind of thing ever. Attend class, catch up on your notes, do your assessment, share your knowledge. It's the only way you can build a community. Otherwise, you're dead in the water. From me, peace. Catch you.